Welcome to Team Tigio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
Please be seated.
Welcome back. We will resume this morning's sitting with the next matter. It is number 21-995, Stevenson versus Stevenson, and I believe we will hear first from Attorney Dickerson. Is that right?
May it please the court. Good morning, Your Honors. Mark Dickerson for the appellant, Michael Stevenson, personal representative of the estate of Genevieve Stevenson. So this case at first blush appears like the normal quantum Merowit case that the courts have seen for a century, including the Hatsopoulos case at Gargis, where a case involving a Greek immigrant who was a baker came to the country in Fall River and took care of his wealthy uncle and gave service to that uncle in the last years of his life. And the uncle, during the time he was being provided health care services, promised him one half of the estate. And then subsequently, after he died, he didn't provide for him in his will. And so what we submit in this case is that, unfortunately, the trial judge, after a bench trial, perceived this to be that line of cases when it was in fact not. So the issue—
Can you move your microphone up a little? I'm sorry.
Sure, sorry, Your Honor. So the issue here was that, unlike those classic cases where the decedent had promised to provide in their will, that promise was kept here. The decedent, Genevieve Stevenson, was extremely clear, and the record's very clear, that she promised, again, the background here is Miss Stevenson had a single asset, her home on Nelson Street in Winchester, Massachusetts. When she made her will back in 2001, she had 4 children. And the will provided that the asset, the estate, would be split 4 ways equally amongst her 4 children. And then subsequent to drafting the will, and after 2012, when Holly, the plaintiff in this case, moved in with her, 2 of her kids had passed away. And so she had 2 surviving children, Holly and Michael. And the evidence at trial was quite clear that basically all that was said in exchange for receiving health care from her daughter Holly was that you're getting one half of the house. That's what you're getting. And by the way, your brother Michael, who is not providing any care services, he's getting one half of the house. So that evidence, there's a lot of heat and emotion at this trial. Unfortunately, like with most family disputes, there was evidence of a tussle at a front yard. There was a secret recording that occurred. There was a lot of evidence that my brother put in about—
Okay, so she was promised if she did all this care, she would get the value of half the house upon death through a bequest.
Right.
Okay? I'm not sure. I have a hard time distinguishing his stupus. Instead, the will was never changed, and she got a quarter of the house through the will.
Right.
Right?
I think when you look at in context—
Did you put in evidence? So she asked for an equitable remedy, quantum Merowit. She says, I was promised half the house. Now then, she says a bunch of stuff about the hourly rate and this and that, and I don't think we know the value of the house, so maybe it doesn't matter. Maybe she got less than the value of half the house. I have no idea.
That was in the record. The value of the house in the accounting was—
All right, so what's the value of the house?
So the value of the house, according to the trial evidence, was sold for $570,000.
And what did she get in damages?
She got $140,000 plus interest. So at the which is—
Well, never mind the interest. $140,000.
Right.
So less than half the house.
She got less than half the house. But here's the inequity of everything, and I want to get back to my main argument, is that she still took a quarter, under the will, she took 1/4. That's undisputed. She's going to get that, plus she's getting the recovery for
Do they together add up to more than half the value of the house?
Absolutely.
Did you argue that her damages should be capped so that she was only rewarded with what she was promised?
The argument below was that was not argued below by trial counsel, but I believe it was saved because the argument was that she's not entitled to anything. And so they never got into the remedy, but the evidence was that, undisputed.
So let's work through this number. So what did she wind up getting from the estate process?
So the estate process is ongoing, but what did happen in the estate administration, this is in the record, I believe there's an accounting that's, you could find it 506 to 512 in the record appendix, volume 2. So what Mr. Stevenson, my client, did is during the initial part of the probate proceedings, before Ms. Holly Stevenson made a claim, there was a distribution. So there's already been a distribution to some of the beneficiaries, including Holly, for $60,000. So she's already received $60,000. Then she brought this claim, and so now she has a creditor's claim for $200,000 in accruing, 140 plus 12% interest.
All right, but if she gets $60,000 and then gets another $140,000 from the judgment, that's still less than half the value of the house.
I didn't finish out the math there, but the issue is that she's already been distributed $60,000, but she would get her 1/4 share, which would be approximately, after you net out the other amounts, would be about $207,000. When you net out the liabilities of the estate. So she's going to essentially...
so what else is in the estate then? I thought the house was the only asset, but now you're telling me 1/4, even after paying this judgment, is going to be $207,000 plus $60,000? No,
that would be the total amount. So...
Okay, it's a simple question. How much is she going to get from the estate process as a beneficiary of the will?
As a beneficiary of the will, she's going to get 1/4 of the net proceeds of the estate.
And what's that going to be approximately?
That would be, I think, as of now, there's approximately $200,000. After the distributions have been made, it would be about 1/4 of $238,000.
1/4 of $238,000. Okay.
So she nets that, plus she's going to get the $200,000 in accruing as a supercreditor of the estate, or a creditor of the estate. So the net breakdown, if everything holds true, is that she's going to...
That looks like she'll get about $120,000 as a descendant. You add in the 140, it's still less than half the house value.
But the problem is that then the rest of Michael, who is supposed to also take half the house, he's only going to get $60,000. And the nieces and nephews are only going to take what they've already received as well. So on balance, the net numbers are going to be, she's going to get at least $235,000. Michael will have gotten $60,000, and the nieces and nephews would have gotten $120,000, which is essentially, she's getting more than she reasonably expected.
She was expecting half the value of the house, and it sounds like she's getting less than that.
Right, but the problem is, with what our fundamental argument is, that she only had a reasonable expectation to get what was in the will. The evidence, when you look at it in context, is that the mother mistakenly understood, because of not accounting for the predeceasement of her 2 other children, she just presumed that that Holly and Michael were going to get half the house.
This was you waived detailed findings of fact, so we have to review this like a jury verdict. So maybe the judge could have inferred that, but it's clear that she didn't. So how do we reverse?
Well, I think it's because it's clearly erroneous based
No,
on.
I mean, there are no factual findings. We can't review it. We can't review for clear error. We have to review like a jury verdict.
Well, then, so you look at the sum total of the evidence and
Right, so if there's anywhere in the evidence something that supports the judge's verdict, then we have to affirm.
That would be true. But what I'm telling you is when you look at the evidence, the actual testimony and evidence on this point was very thin. And it basically was that, and this is essentially from the plaintiff, Holly testifying, that what her mother told her was that she would get half the house and that Michael was going to get half the house, which meant the mother Genevieve presumed that by the way that her will would work, with having had 2 of her kids predeceased, that each of them were going to share equally. But she was mistaken, and frankly, so was the plaintiff and my client, Michael Stevenson. So what the whole point is that Holly had no reasonable expectation that she was going to get, her only reasonable expectation is she was going to get whatever was in the will, because that's what everybody was essentially talking about, that she was going, they presumed that the will would provide that she and Michael take equally.
But you're challenging, no, never mind.
She told me I was getting half of the house. That's the testimony.
Right. That's the testimony, but also the testimony is not only.
Well, but look, and I'm not sure I really understand how you would defend that, but what you're really saying is there was like a mistake about what the will actually did. But this isn't a reformation action where Michael and Holly have together said, look, Mom misunderstood that when her children died, she didn't know that their issue would count as quarter recipients, and so she's told all of us all this time this, and we'd like to, I don't know that you get it reformed, right? But, so that's sort of what you're saying.
Well,
right, so you're conflating, you're saying the only reasonable way for a finder of fact to read you're getting half the house is you're getting what's in my will. And the judge didn't read it that way, right? The judge clearly read it, you're getting the value of half the house, or something, or you're getting some reasonable value for the services you're performing.
Right. Well, let's take, there's 2 things here. So first of all, the judge made a finding that she determined what the reasonable value of services were and made her findings on that. That's pretty clear, and didn't do any calculation as to what the value of half the house was.
Well, I understand that, but this is quantum merit. It would have been your obligation, it seems to me, to say whatever the reasonable value of the services has to be capped at what she was promised. But it doesn't, right, if it does go over that cap, which I'm still not totally.
But getting back to your first point, Your Honor, it's not that we're seeking reformation of the will. The point is that when you look at this record quite clearly, in the context of what the expectations of Holly were and what her mother was telling her, is that there was essentially the agreement between them was you're only getting what's in the will. That was the understanding. That was the agreement. They had a mistaken understanding as to what was.
She told me I was getting half of the house. That's the testimony, and the judge could credit that, right?
She could credit that, but what she was really saying, when she also testified, and this is Holly, she's saying this at the same time in different places in the record, she's saying, Mom told me I'm getting half the house, but Michael is also getting half the house. So the only logical conclusion on this record is that there was no consideration, additional consideration for Holly with respect to the healthcare services she was providing. In other words, even though Holly was providing services to her mother that Michael didn't provide, she was only getting the same exact amount.
But it's a little weird, right? Because what we're saying here is, I think all you're saying is, it's not like the mother thought, I have to go change the will to make sure she gets half the house and then failed to do so.
Right.
You're saying the mother thought she had provided her with half the house and Michael with half the house.
Correct.
That is not what she did. And she didn't do it because she didn't understand the law. None of the parties apparently did,
Right.
I guess. I don't
That's
know.
right, but the burden on the plaintiff here was to show on a quantum merit claim that the plaintiff, Holly, had a reasonable expectation of getting additional compensation for her health care services. And she never said that. There was never any testimony about that. There was never any expectation.
You're saying there could be no finding of fact that she had a reasonable expectation of anything other than what was in the will, because what she was told was, you're getting half the house because that's what's in the will.
Exactly, but because remember, there's a single asset, one house, and she's saying, you and your brother are splitting the house. So that means, and it's understood, that she's getting absolutely nothing else for doing the health care services. So now, fast forward to where we are, Holly is going to get
Look, I get that the money comes partly from Michael and doesn't come all from the other grandchildren, but that's...
right, but one thing I want to bring to the attention of the court is that...
Yes.
I'm sorry to talk over you, Your Honor.
No, but your time has expired, so...
But, the fundamental premise of quantum merit is that to live up to everyone's reasonable expectations.
Okay.
And there's a principle, an ancient rule that people who elect to who receive a beneficial interest under the will can also bring a claim.
We have your brief, so we understand your argument. Your time has expired. Thank you very much. We will hear now from Attorney Carr.
Morning, Your Honors. David Carr, representing the appellee, Holly Stevenson. May it please the court, Your Honor, this has been a difficult case insofar as distinguishing the claim of Holly Stevenson from the beginning. There was no claim against her mother or alleging that her mother promised her to change her will or to create a will or to otherwise provide for her in her estate plan.
But how else does she get half the house after the mother dies than through an estate plan?
Your Honor, I think Judge Rubin touched upon this. There was just an incorrect assumption on the side of the decedent. She communicated that to both her two surviving children, Holly and Michael, that, look, you're the only two survivors, you're going to get half of the estate. It has nothing to do with Holly leaving her home in Nevada, coming to live with her mother to provide services after she had a heart attack and required someone to commit her to 24-hour care in her home when she was faced with discharge from a rehab that you would either go to a nursing home or you could go back home and have your daughter provide the same services that a nursing home would provide. That is the claim that was made in all of the pleadings filed by the plaintiff.
But I don't understand. She has to have a reasonable expectation of compensation for that.
There's no question, Your Honor, and those were the findings in the Superior Court, that Mrs. Stevenson did attempt toward the end of her life to free up equity in her home, as she did during her life for her son Michael when he asked for money. She was of very minimal means. The only asset, as you've heard, is the house. It was Holly Stevenson's efforts to keep her mother in her home.
I'm sorry, I'm a little confused by your argument here. Are you saying that it's not the promise that she would get money in the will that led to her reasonable expectation of compensation?
It is not, Your Honor. It is the decedent's awareness of the costs of nursing home care, her firm disposition of not going to a nursing home, knowing that those services were going to be provided. There was value to those services. The case law says, it's Butler versus Butler, I believe, and others, that if there's an expectation or a standard of someone who receives those services for over 2 years, several years, that they accept those services, that person would know, otherwise it would cost a lot of money for those same services to be provided.
That's your view of the basis of the judgment below, not the promise, I will give you half the house.
Absolutely not, Your Honor. And I point out in the record, that is not, in my opinion, not an accurate disposition. It's a quote. It is a quote. There's also a quote when Holly Stevenson was asked, and this is at the record at page 68, Holly, are you seeking compensation for the services you rendered to your mother from 2000 or from May 8th, 2015 through her date of death? Are you seeking reasonable compensation? The answer, yes.
Yeah, but the amount, I don't understand how you can say, unless it's disputed somewhere, yes, the mother thought Holly was helping her, and her promise, her explicit promise of compensation, unless I'm misunderstanding this case, was not, after I die, the estate will have some cash when they sell the house and they'll pay you an hourly rate. Her belief expressed to Holly, who didn't have to stay having heard it, was, you'll get half the house. No?
No, Your Honor. The findings below, which are before you, and obviously the standard clearly erroneous, we have the trial judge finding that was there a reasonable expectation that Holly would be compensated? The answer is yes, and that was on both sides.
Yeah, the expectation that she'd be compensated by being in the will and getting half the house. That's what she testified to.
Not true, Your Honor. It's not. It has nothing to do with the decedent's will. Never a claim made against that will. I understand you're focused on the compensation or the...
Okay, well, so as far as I could see, your case turns on, she told me I was getting half of the house. So if there's other evidence about the expectation that in this trial transcript, I would like you to point me to it.
Well, Your Honor, I've just pointed out, for example, did you testify earlier that you believe compensation would come in the form of receiving proceeds from the sale of the house? Answer, yes.
But the testimony from before was half of it. Yes, I'd get half of that, right?
Sale of the house, which was going to happen after death.
The understanding, Your Honor, and I think you touched on it, Judge Rubin, was that the decedent misunderstood the significance of having her two children predeceased and having two other children survive. There was a mistake on the part of Michael Stevenson. But that's not what's before this court. What's before this court is the findings of the lower court, which are clear that the compensation was expected to be paid by the decedent, and it was expected on the part of Holly Stevenson to be paid for those services.
While she was alive?
Not while she was alive. From
when
the
she was
estate.
Dead?
After her demise.
How does one obligate one's... So now, I think you're digging yourself a hole here, but let's keep going. Now, you're saying the expectation was that she would get something from the estate.
That's correct, Your Honor.
Okay, and so are you suing the estate to get that something under the contract? I thought this was quantum merit.
It is quantum merit, Your Honor.
But under the contract, the estate is supposed to give her, what, half the value of the house?
Your Honor, contract claims in this case were dismissed. It went forward.
Yes, I'm aware of that. They have to be dismissed, right? Because there's no writing.
That's correct. In order for quantum merit to go forward at the trial level, which it did, the contract cases were dismissed. They are mutually exclusive.
I agree with that.
So we proceeded on the quantum merit. It was found that she had an expectation, Holly, of payment for the services that she rendered. The decedent had an expectation to pay her.
Right, and the expectation was that would be paid by her getting half the house through the will.
Your Honor, that is incorrect.
Why are you fighting that? That's the Histupus case, right? In the Histupus case, the guy is promised that he'll have money in a will. It's not put in the will, and he gets to sue the estate and get the value he would have had. Isn't that this case?
This case is the services were rendered.
Just like Histupus?
Just like Histupus. There was evidence of what the reasonable value of those services were presented by an expert witness.
Yes, but no one ever said, the mother was, I think, both of them, unless there's something in the record like Justice Ditkoff asked for, both of them were quite clear that it wasn't going to be some hourly rate. I'm so glad I get to stay here and have you do this instead of the nursing home. I'll pay you. That might be the value of the services for quantum Merowith purposes as a remedy. But what was promised was half the house through the will. Just like in his stupus, what was promised was a bequest. That bequest was not provided, and you brought this suit. But you're now telling me, no, that's wrong.
It is, Your Honor. There was no request or no claim on the part of the plaintiff to sue under a promise that her services be compensated for through the will. No allegation.
Could you tell me where in this transcript I will find any evidence to support the proposition that your client reasonably expected that she'd be compensated other than through getting half of the house in the will? Where's the testimony?
Your Honor,
I didn't see it. I read the whole transcript.
In the, I think it's pages 169, 180 of the record, the question to Holly on the stand was, did you testify earlier that you believe your compensation would be in the form of receiving proceeds from the sale of your mother's house? The answer is yes. Genevieve never had, this is the decedent, Genevieve never had any cash on hand to pay you during her life, did she? No. The expectation was she was going to be paid in the same form as any creditor from the estate.
Where does it say that? Same form as any creditor?
Well, Your Honor, in the transcript itself, there was
what page are you at?
In the transcript, and I don't have the exact page, the dialogue between trial counsel and Judge Kazanjian was an example where how does any creditor
but we need
paid?
Testimony of witnesses to support this. She believed that she would be paid in the form of receiving proceeds from the sale of her mother's house.
Correct.
Right. Which happens because she's in the will and is going to get half the house in the will. I don't see how that suggests anything other than what she testified to.
I think what Justice Ditkoff is saying is that could mean either of two things. It might mean the estate doesn't have any cash in it. It's going to have some creditors. It's going to have to sell the house. It will then have a pile of money, and I'll get paid my reasonable compensation. Or that might be another way of saying, well, the house is going to be left to my brother and me. We're going to sell it, and I'll get half the proceeds of the sale of the house. And what Justice Ditkoff is saying is, particularly, let me add, given the reference to what you said before, was you thought the latter. You thought that your compensation was in the form of a bequest of half the house. You're saying somewhere in this record we can find that no, what she thought was the estate would sell the house, and like any other creditor, she would be able to come in with her invoices and get paid.
That was the case, Your Honor, that was tried in the lower court.
So if I look at closing arguments, that's what I'm going to see being argued to the judge.
There's no question, Your Honor.
Okay.
No question.
Fascinating. All right.
The judge found the former, right? I mean, we have to read between the lines because she didn't make findings, but based on the exchange with counsel and the judge, it seems to me that she found the former.
She found, yes, that services were rendered, that there was an expectation on both sides of that equation, if you will, that of payment.
And what evidence is there that the mother expected that there would be a payment of cash from the estate rather than a bequest?
I think the record is clear when she was faced with her options of either going home or faced with nursing home care. She was aware of the costs, or it could be gleaned from her testimony, and I think the record will be clear, ultimately very clear, that she was faced with those expenses and being upset at having to go to a nursing home or go home with Holly, who was going to provide those services, knowing that there was a cost associated with that arrangement.
I don't think that answers the question, but
Well, you're saying we have to draw an inference. We draw an inference from her decision to be cared for by her daughter at home rather than by a nursing home, that she would pay some reasonable fee, essentially, to her daughter for providing the care.
I think, well, what's before you is the findings of the lower court.
Sure, and we can't, because it was this waived, findings of fact waived trial, we can't look far behind that, right? So,
And you'll see that those findings were made, that there was an expectation.
we are wondering if they're supported, not whether they were made. We're wondering if there is support for your version of what it means to be reasonably compensated.
Yes, Your Honor, you will see the dynamics throughout the trial transcript of the defense claiming that this should be a statute of frauds issue, that there was a promise to change a will. Again, no allegation on the part of the
But that's just an erroneous argument that there's no quantum merit here. It's not, doesn't tell us anything about the form of the alleged promise, but all right.
so the judge made some mention of the testimony about the reverse mortgage. You're not relying on that?
I'm sorry, Your Honor.
You're not relying on that testimony about the reverse mortgage?
Yes, to a certain extent, the judge was asking for what is the clear evidence of the understanding of the decedent at that time. And there was efforts to free up money from the equity of the home to pay Holly.
Which they ultimately failed, though, those efforts.
It did not occur. Go ahead.
What
Sorry.
efforts in this testimony? Did you have discussions about reverse mortgages? Yeah, it was probably the month or 2 months before she got released, and I had cut way down, ultimately stopped working in December. Was there any action to take respect in that? No. So where's the evidence that anything happened? All I see in this transcript is there was a discussion.
There was a discussion. It did not happen. There was not an equity. If Mrs. had the cash, we would argue that she would be compensating Holly on an ongoing basis. She did not. I mean, Holly moved in. She quit her job toward the end of her mother's care. They were running out of money. They only had the decedent's Social Security income, and due to Holly's efforts to keep her in her mother's house, she actually, ironically, saved the home from a mass health lien, and there would, without her efforts, there would be no home to an equity to dispute here.
All right,
None
I think your time's expired. I think we understand this case better than we did going in, I think, or maybe less, but I think more.
Thank you, Your Honor.
One of the two.
The case is submitted, certainly not exactly the same amount as before. Our final matter for this morning is Anderson versus Odife, 21-1162. And with apologies for mispronouncing your name, I believe we'll hear first from Mr. Mingachi. Exactly. All right.
Good morning, Justices. If it please the Court, my name is Chris Mingase, and I'm representing the appellant in this matter, which is Odife, Dr. Amiche Odife. This matter comes before you from a decision from the court, the land court, that was entered back on August 12th of 2021 involving a Mass General Laws Chapter 241 matter, which was a petition to partition filed by Doreen Anderson on a property in Worcester that was owned in common with Dr. Odife. The issues that we are appealing today deal with the second part